What's the story of McCulloch versus Maryland? Well, Maryland imposes a tax on all banks operating in Maryland that don't have charters. There was exactly one bank operating in Maryland without a state charter. That was the Baltimore branch of the Bank of the United States. So James McCulloch, the cashier, says, I'm not paying this tax. The Maryland courts say, oh, yes, you will. And that's what goes to the Supreme Court of the United States in 1819. There were two discrete issues: whether Congress actually had the power to incorporate a national bank. If Congress had in fact validly chartered a national bank, could the state of Maryland tax it nonetheless? So once the court has these two questions in front of it, what does it say? Sweeping victory for the bank. The court says, well, of course Congress has the valid power to charter this national bank. And by the force of the Constitution itself, Maryland cannot tax that bank. This was a unanimous opinion by the Supreme Court. All members of the court agreed that Congress had the power to create this national bank. The claimed source of federal authority was Article 1, Section 8, Clause 18, saying Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Well, the key argument raised by the parties in this case focused only on one small component, and that was the word necessary. The focus of argument was on whether or not it was necessary for carrying into execution federal powers. Actually, the decision by the court on that point is intellectually one of its weakest. It's an interesting tale. When the second Bank of the United States, the first by some accounts, was created by Congress in 1791, President Washington had to decide whether he was going to sign the bill. And Alexander Hamilton said, well, of course, this is a great idea and obviously constitutional. Why? Well, because, said Hamilton, necessary just means, in common parlance, helpful, useful, conducive to. 3 decades later, Chief Justice Marshall takes almost exactly Hamilton's language from 1791 and puts it into the opinion in McCulloch versus Maryland, saying frequently imports no more than that one thing is convenient or useful or essential to another. So they're making a linguistic claim about the way that the word necessary is often used. Here's the thing. A couple of years ago, Steve Calabresi, Elise Kostiel, and I did a very, very long law review article where we looked at dictionaries from the founding era. We looked at the contextual background of the necessary and proper clause. There is exactly zero evidence to support the linguistic claim of Hamilton and Marshall. Now, that doesn't mean that the state of Maryland was correct in the case, because the state of Maryland took an equally difficult to defend an extreme position. Maryland in 1819 said that, well, necessary, that means absolutely indispensable. You can't possibly get off the ground without it. That also isn't supported by the available linguistic evidence. The person who actually had it right was James Madison, saying that as long as there is a obvious and definite connection between one thing and another, that's sufficient to make it necessary. So, right or wrong, from 1819, what's been the precedential effect of McCulloch? Whether or not Marshall and Hamilton's account of necessary is correct, and I think it pretty obviously is not as an original matter, it has driven doctrine for 2 centuries. The modern court has translated it into the language of rational basis, which is code for the government wins. And indeed, in the entire history of the United States, no congressional statute has ever been found by the Supreme Court unconstitutional on the ground that it was not necessary under the necessary and proper clause. So that's had a very, very sweeping effect.